Roger's correct. I always joke that I deal with the tax law, I deal with about everything except I have a no-contact contract with ERISA. I don't have much, and I also don't particularly care for Section 409A. Because I've never been able to figure out how it is that you can't value an option for purposes of Section 83, but yet if you don't use the underlying stock value for 409A, suddenly the skies fall and they kill the poor recipient of the stock option. So my topic today is partnerships. Because I've been a tax lawyer so long, I'm technologically impaired. So if I get a little trouble with the slides, you'll have to deal with it. As long as it deals with the code section, I'm fine. The computer and I are so-so. So the first, trying to decide how to address this topic, as partnerships are so broad, I wasn't quite sure what to do. So I picked what I thought are some areas that we come across somewhat frequently, and I thought that would be the basis for my talk. And then if you have questions, hopefully I'll leave some time at the end. So the first question is there a partnership? And this is like obscenity. It's kind of depends upon who the judge is at the time. Once you get through looking at the cases, and Lauren can talk about that a little bit more because she's had a couple of cases where the judges go down all the factors, you hit a home run, you tag all the bases, and the judge says, nah, I don't like the taxpayer, you're out. So the code itself is a definition of partnership, really two places. It's in section 761A and in 7701A2. And the definition is, if my glasses will let me read it, it's for purposes of this subtitle, the term partnership includes a syndicate, group, pool, joint venture, or other unincorporated organization by means of which, and to me these are the critical words, any business, financial operation, or venture is carried on, and essentially which isn't a corporation or a trust or estate, so they really define it almost in a negative. Now, whether you have a partnership or not, from my standpoint, depends upon whose ox is being gored. The government takes inconsistent positions, the taxpayer takes inconsistent positions. It just kind of depends on the result they're seeking. One of the situations where this issue arises is in the employee versus agent versus partnership. What will typically happen is somebody who's maybe a legal employee or agent is trying somehow to get capital gain by arguing that they've got a partnership interest and that's what they're disposing of. One of the leading cases in this area is Luna versus Commissioner, and in this case, this involved an insurance fellow, and he essentially was cashed out of his insurance renewal commission rights. And he argued that that transaction was a sale or exchange of a capital asset, and therefore he should get long-term capital gain. The court's conclusion was no. And they went through a series of 8 factors, of course, none of which is a bright line, according to the courts, although as we go through, I think you'll see there are some places where they kind of coalesce. One of the first requirements is, what's the agreement of the parties and their conduct in executing it? And I've seen a lot of times where people draft partnership agreements, they don't follow it, and then I know you as CPAs, you're trying to do what's fair. Frequently the lawyer drafted it doesn't have a clue what he did, probably stuck in targeted allocations, which he couldn't explain to anybody if you asked him when they're preferred returns or guaranteed payments. And so I think to the extent you can follow the agreement, it pays to do it. Lauren had a case where the taxpayer didn't, and the judge just jammed it down the taxpayer's throat and said, no partnership. The contributions that the parties make to the venture, the parties' control over income and capital, I don't think these are particularly important today given the fact that so many partnerships are either limited partnerships or LLCs. So this case really arose, it's an older case, and it arose when more typically you saw general partnerships. Whether each party was a principal or proprietor, I think that's a so-so factor given LLCs and limited partnerships. I think this is important. And whether they have an interest in net profits and an obligation to share losses. Oh, the first slide, I forget. And I think if you're sharing net profits and losses, you can be pretty sure you've got a partnership. That's my view when I look at all these different authorities. Whether business is conducted in the name of the parties, in other words, are you holding yourself out to other people as a partnership, whether you file partnership returns. This to me is a make-weight factor, but I think when you file a partnership return, it's very difficult to argue that you're not, because I think Lauren would probably tell you it's an admission on your part that you think you're a partnership. So I think that one is used as a kind of a push them over the hill factor in a number of the cases. Whether you maintain separate books of account and mutual control, again, I think the synthesis of that is, are you sharing net profits and losses? And in Luna, they concluded that was not the case. As many of you may know, it's the government's position, the IRS's position, an old revenue ruling, and I'm not quite sure that it actually relies on something from the 39 code, so old before I was even born. And the government's position is that when you're a partner, you cannot be an employee for withholding tax purposes, for FICA, and for FUTA. Now I know, and I've heard of a number of people who, in the case of guaranteed payments, that they treat as salary and will give partners W-2s. I don't think that's proper given the government's position. My view is, as long as the tax gets paid, it's probably no harm, no foul. But you want to make sure, if you're doing that, that the employer's side is paid, because again, the government's position is that this is self-employment income, and the burden for all of the payments, so who then gets an above the line deduction for I guess half of what they've paid. So another situation where this issue arises, and I guess I'm still on the first slide, is the co-ownership situation. A leading case in this area that has always bothered me is Madison Gas and Electric versus Commissioner. This case involved 3 utilities who developed and operated a nuclear power plant. And the taxpayer in this case argued no partnership, and the IRS said no, there is. And the reason the issue arose was the taxpayers were arguing that all their startup expenses were deductible under Section 162 because they said this is just an expansion of our existing trade or business. The IRS said no, it's a new business, and therefore you cannot start deducting expenses until you actually start. So that was the synthesis of how the case arose. I think the factor that, well, there are a number of factors that they considered, but I think that the key factor was that even though the co-owners sold their shares of the power separately, the fact that they developed and operated the facility was sufficient for the government to say there was a business and therefore there was a partnership. And then their taxpayer loss was unable to deduct what were then deemed startup expenses. This case is actually, I think it's before Section 195 on startup expenses, but it forced capitalization. This case is not easy from my standpoint to reconcile, because they're with other published rulings and even the regs. For example, as many of you know, in the real estate context, there's a published revenue ruling that's been out there for a while, and it's kind of followed in the regs, 75-374. This is a typical case, 2 people own a partnership, own an apartment building. They rent it. They have an agent who really handles everything for them. They don't provide extraordinary services. They just, trash, unattended parking or whatnot. And the government ruled in that case they would treat the arrangement as a partnership. The regs have an example of building a drainage ditch, two parties cooperating on that, and they said, no, that's not a partnership. They almost recite the ruling again. Again, the real issue is if you have attended parking, that seems to be what pushes you across the line, or you're doing anything at all that looks to the government to be a business. Again, I find getting bright lines here very difficult. Where this often comes up, well, a few more. Just sharing expenses itself won't make you a partnership. That makes sense because you're not sharing net profits. So that's the drainage ditch example. And where this comes up in a lot of cases is in the Section 1031 case, where people are trading out of property and they want to go into something else. And the question is, are they trading into a partnership, which is a no-no under Section 1031, or are they trading into a tenant common interest, which is an ownership interest in real property that would qualify under Section 1031. The IRS has issued a revenue procedure with many of what I would consider extreme requirements for them to rule that you have a partnership, you have a co-tenancy, I'm sorry, rather than a partnership for tax purposes and in the trade area. And the one that I find the trickiest, because you can comply with most of the requirements of that revenue procedure by structuring your transaction so that your promoter or the party wanting to trade, let's say, forms a wholly owned LLC that your promoter can be the manager of, so he knows he can control the property, and that wholly owned LLC can then be a TIC, tenant in common with the real property owner. A case that I had where this arose recently, though, was we had raw land that was being developed. And the question was, could the party who wanted to do the trade into the property, or was the act of development sufficient that there was a business that you then had a partnership that threw you into 1031? The revenue procedure is unhelpful on the point because it assumes that there is a business. It already talks about renting and whatnot, and so there are ways to deal with that type of situation, but it's just not clear whether you can trade into a property that's being built, and would that be a business such that you are treated as trading into a partnership and therefore blowing your trade. If I remember, I'll tell you how some of the ways we sought to circumvent that problem. Interestingly enough, as I said, in this area, there's just not a lot of clarity. The government has also ruled, there's a published revenue ruling, it's 81-150, and here the taxpayer was arguing partnership, and the IRS said, well, let's see, your activity is you were formed to build and operate a drilling rig, an oil drilling rig. Well, until you start operating, you're not in the business. So they said no partnership. So to me, that's inconsistent with the fact that development of a property would put you in a business that would create a partnership that would throw you into 1031. But as I said, there are just not a lot of bright lines here. Another area where this arises, this partnership or non-partnership status arises, is in the debtor-creditor relationship. And this comes up frequently where you've got a development project, development partnership. You'd like to get tax exempts involved in the deal, but they don't want unrelated trade or business income. And it's very difficult to fit within the, I think it's 514C9, the qualified allocations that would necessarily protect the tax exempt. So many times we seek to bring the tax exempt in as a creditor and with some kind of like equity kicker so that they can invest in the project. Now, a recent debtor-creditor case that arose, I guess it's not so recent anymore, was it's called TIFD Roman numeral 3E versus US. In this case, the game was essentially trying to allocate income to foreign banks who wouldn't pay tax in the US. The court concluded that the banks were essentially secured creditors, and they relied on the following factors. They said the banks were promised reimbursement on a previously agreed on schedule and an agreed return. Exposure to risk repayment at the agreed rate of return was secured by the personal guarantee of the parent of the taxable partner. One thing about the government, and Lauren always comments, the government doesn't understand the concept of risk. That's because they go home at 5 o'clock. Because as you and I know, the fact that they think this thing is guaranteed may not be guaranteed, because the fact that somebody guaranteed it doesn't mean that they'll be able to pay the guarantee when it gets called. So, but these are factors that the court considers. They were protected against loss. Their ability to share in the net profits was capped. And I always consider this a critical factor, that if you cap somebody's interest in the venture, it's going to be difficult to argue that they're a partnership. I always like some residual, whether it's 1%, 5%. People disagree. Obviously, the more you can give them as a residual, I think the safer that you are. So capping them to me is a no-no. I think it converts it into debt. Actually, one of the cases that Lauren had, I think, a couple of years ago, and I think it just went up on appeal and was decided against the taxpayer, the cap was used as a critical factor in finding no partnership, where the taxpayer was seeking to allocate income to an S corporation wholly owned by ESOPs, and you guessed the IRS didn't like that because nobody was paying tax on the income. And they said the fact that you cap the income going to the S corp, that's a no-no, that's a factor that it's not a partnership. So looking at this case, this TIFD Roman numeral 3, I called a series of factors that I consider when I'm trying to structure something as debt in this partnership context. Is there a fixed interest rate of interest payable without regard to the income of the debtor? What's the expectation of payment? Can the creditor essentially call the loan? Is there any meaningful stake of the creditor in the success of the business? Can the creditor force dissolution of the venture if it doesn't get paid on time? Is there an unconditional promise to pay a sum certain? That's a very typical debt factor many of you are familiar with. Right of the creditor participate in management, I don't think that's significant because of the LLCs and limited partnerships that we have. This one is a critical one, and it's a problem in trying to structure these situations as debt. No subordination to general creditors. I had a case recently where in a development project, which would have generated UBTI because it was going to operate a business, we wanted to bring tax exempts in. The question was how to do that when we were going to be building the property, we were going to have a lot of debt on it, all of which was going to create problem for the tax exempts, and we needed to count the tax exempts money for purposes of equity in getting the loan. So we were kind of in a catch-22. So what we did was we structured the debt so that it was subordinated to the secured creditor, but not to general creditors. And then I think we can take the position that it's in fact debt because they stand as all general creditors, and then they have a kicker that we gave them in the deal to kind of bring them up to a quasi-partnership status. We also wanted to issue this to tax exempts because we weren't going to pay the interest for the first couple of years. And that, of course, generates original issue discount, and most taxable people don't like that. They don't like income with no money, whereas the tax exempts don't care because they love interest, you know, dividends and rent and all that stuff. Let's see, that's debtor kicker. Yeah, there are just a number of different cases in this area on the debtor creditor, and it is difficult to reconcile them. But again, I think if you have no subordination to general creditors, fixed time for payment, then I think you're probably okay. Another situation where this will arise is this partnership status or not is in the lessor-lessee relationship. And the courts have held that the sharing of expenses is not enough to make you a partnership, as I said earlier. And it really, it's got to be all expenses, by the way, not just some of the expenses. So you may be able to avoid partnership status by limiting the expenses in which they share, assuming you don't have the net profit situation coming to hit you from the other side. There are a number of different rulings on this involving crop sharing relationships and cases, all dealing with this issue. Actually, in one case, they held that sharing net profits didn't necessarily create a partnership where there wasn't some other evidence of a partnership, such as sharing of losses, expenses, and whatnot. Again, if you file a partnership return and you have any other factor, they're going to probably argue you're a partnership because they're going to, the government will use that as an admission that you think you're a partnership. In the situation I mentioned to you about the problem trading into a project being developed. One of the ways we considered of circumventing the problem was to have the trade occur into the property and then immediately have the trading party lease its tenant in common interest. So let's say you have A who owns the property, who's developing it, B wants to trade into it. So we have A and B trade, let's say for half the property, and then B immediately turns around and leases, let's say for 5 years, on some basis it's not sharing all expenses and all the other stuff, to A for let's say 4 or 5 years while the project's being developed, and then at the end of 5 years we can always put it into partnership because we're outside the time that the government could argue that B traded into a business with A. One of my favorite cases in this area about is there a partnership or not is a case called Redd, R-E-D-D versus Commissioner. Very difficult to find this case, but it's an early partnership case in a different world, because the government put the taxpayer's wife on the stand, and they asked her, now, do you participate in the management of the business of the LaSalle Livestock Company? And she testified, well, I've been producing partners. The question, the guy said, beg pardon? She says, I've been too busy producing partners so far. This was a family partnership case when you couldn't do joint returns, and also they were trying to allocate the income to the kids, and actually they even had a schedule where you would just add the kid's name as they were born to the partnership agreement. So my conclusion is whether or not you have a partnership or not for federal income tax purposes really depends upon the tax result that the two parties are seeking. The government and taxpayer, they just have different goals, and they'll take different positions depending upon the result they want. As I said, bright lines aren't always there to guide you, and this reminds me of the fact that now you see it, now you don't. There was a fellow who had, I think, $3 million. He decided that, unlike everyone else, when he died, he was going to take his money with him. So he called his lawyer, his doctor, and his minister to his deathbed, and he said, I want to take it with me. I'm going to give you each $1 million. When I die, I want you each to throw in the envelope with the $1 million. So he passes on, and as they're leaving, the doctor says to the other three, well, I'm a bit embarrassed. I only threw in $750 because our hospital's kind of falling down and we need some repairs. And I thought this would be a good use, so I just threw in $750. Well, the minister says, I'm also embarrassed. The church is kind of falling down and needs some restructuring and stuff, and so I only threw in $500,000. And the lawyer looks at him, of course, the tax lawyer, and he says, gentlemen, I'm ashamed of both of you. I threw in my check for the entire $1 million. So it just all depends. Everybody does what they think is correct. Now, I guess I go to my next slide. Let's see if I can do it. Did I do it? Yeah. Well, it's on here. Yay! Hooray! Hooray! Okay. So my next topic is transactions between partners and partnerships. There's a number of different situations where issues arise here. One of the first is the disguised sale area, where the code was amended, I think, 86 or something like that, to prevent people from using the Section 731, where you make a contribution to the partnership, you make a distribution out under Section 731, arguing you've not got enough basis, and therefore you don't have any gain, and you've kind of done a bad like-kind exchange using the partnership provisions. So to put a stop to this, the IRS went, as they frequently do, crying to Congress, and got them to add to the code Section 707A2B. And it's aimed at this type of situation where there's a contribution of property by a partner followed by a distribution of cash or other property back to the contributing partner. And based on all the facts and circumstances, one would have happened but for the other. It also can happen where the transfers are not simultaneous, where the distribution out to the contributing partner is not dependent on entrepreneurial risk. This is all set forth in Treasury Regulation 1.707-3B, and there are a number of different factors that are listed, including the timing of the transfers, which is probably the most critical factor because there are presumptions, and if this transfer of property, the contribution, and the transfer of money happen within a 2-year period, you're presumed to be bad. And they require disclosures if you do this to let them know. Although I wonder sometimes they're so overwhelmed they sometimes return Section 83B elections, so I don't know what they do if people disclose this. But in any event, it's set there. You're required to disclose to them that you've made this transfer within 2 years and then gotten the distribution of money. If the transfer and the distribution of money are more than 2 years apart, then there's no presumption that there's a bad act here, absent, of course, other facts and circumstances. You know, they never can leave you with a totally bright line. There are exceptions to this rule for reasonable preferred returns and guaranteed payments, and reimbursement of certain capital expenses that are incurred within 2 years of the contributing partner's transfer of the property. This will often happen where somebody's developing, they put debt on it, making capital expenditures toward improvement, and then they run out of money and they got to bring somebody into the deal. So reimbursing them in that case may work. Assumption of liabilities is also treated as a transfer of money. So if you have the situation where there's liability put on property within 2 years, you may walk into the disguised sale rules unless you can get around it by arguing reimbursement of capital expenditures and whatnot. And again, it's a 2-year presumption. And if you don't have qualified liabilities, that is liabilities incurred more than 2 years before the contribution, again, you need to disclose to the government what you've done. A second area where, and this one, the regs are very recent. The code provision, again, has been in there for almost 20 years. The government was concerned. There was a game we used to play, some of you may remember, where we were trying to effectively deduct expenses that should be capitalized by allocating gross income. And we used to, for example, we'd have an architect on a project. We'd admit him to the partnership, figure out what his fee is, get a pretty good idea of what that would translate into gross income, allocate them gross income, which came off the top, which was effectively like a deduction, and then we were happy and we got our benefit. To deal with this, the government, Congress passed Section 707A2B, which is aimed at putting the kibosh on these types of transactions. The architect was the classic case. So when you go through the regs, there is usual a myriad of different factors, but the critical factor is entrepreneurial risk. And every time I look at this, I keep thinking, again, my daughter's comment that the government doesn't understand risk. The fact that you've allocated gross income to the guy doesn't, or the lady architect, doesn't mean they're going to get it. They always assume you're going to get it. And as we know, many times you don't. If the project's a bust, it goes over, you can't get the money to cover, there's not going to be necessarily any gross income, certainly anything you can pay out because the bank's going to take everything. So notwithstanding that fact, there are proposed regs now trying to implement this section. I don't know why it took them so long. Besides entrepreneurial risk and looking at this situation on disguised payment for services, other factors that they consider are the duration of the partnership interest. In other words, it's a short term, whether the time frame for payment compares to how you pay a non-partner service provider, why the service provider became a partner, and are you trying to achieve tax benefits you couldn't otherwise achieve, such as allocating gross income to the architect so you can deduct expenses that should be capitalized. as part of these proposed regulations, the government, I don't know how many of you are involved with VC funds and hedge funds, but there's a game that people have been playing for probably about the past, I don't know, maybe it's 5, 6, 8 years or something, where the general partner or manager of the LLC, whatever, decide, you know, I don't like this fee that I'm getting. It's 2.5%. It's ordinary income. I like capital gain better. So what I'm going to do is I'm going to waive my fee. In exchange, I'm going to increase my profit share. Again, the government doesn't understand the concept of risk. I'd rather get the fee. I'll pay the tax because I know I'm going to get the money. Whereas with the allocation of income, you better have a profit or you're not going to get it. But notwithstanding that, the government's got a bee in its bonnet on it, and they've included these fee waivers as a no-no in their proposed regs. And they interestingly added in that unless you have a clawback, that they're going to disallow the fee waivers, whether it's a fee waiver by the affiliate of the manager or the fee waiver by the manager itself in exchange for the profit share. These proposed regs also take the position that on these fee waiver cases, you cannot rely on Revenue Procedure 9327, which many of you probably know in substance if you don't know the number. It's the one that profits interest for services, we won't tax you in general. The IRS's position as to fee waivers is that these, it's stated in the preamble to the proposed regs that they represent existing law. I love how they try to make their litigation argument in the preamble to proposed regs, which the courts say are just kind of their, like a law review article. It's just their view till they're adopted. Interestingly enough, these proposed regs, and I'm not sure why this is in there, because I don't see how it fits with disguised payments for services. They also contain a brief discussion of targeted capital accounts, which is another subject. I'm not a fan of those. I've rarely met, yes, I have yet to meet a CPA who says they actually understand them. I know the lawyers don't understand them half the time. And the CPA just does what they think is fair in terms of trying to allocate the income, especially where you have preferred returns and guaranteed payments, as I said earlier. But what the regs say, and I'm not sure why this is in there, but they have this quote. It says, they briefly say, well, we think that the existing 704B regs answer the question whether targeted allocations work or not. And then they have this cryptic comment. No inference is intended as to whether and when targeted capital accounts could satisfy the economic equivalence rule. So that's like a little hit under the belt there. So who knows why they'll come out. I don't see why they care as long as somebody's paying tax on the income, but who knows. Another area involving, we're still on transactions between partners and partnerships that comes up that's not always intuitive are the loss disallowance rules. And that is if you have a sale or exchange of, usually it's depreciable property or other property between related partnerships or a partner in a related partnership, it's 50% or more, I think, of profits or capital, the loss is disallowed. Kind of like Section 267, it passes over to the related party, but it doesn't do any good to the seller. So you need to be very careful when you structure that you're not walking into a loss disallowance. Similarly, and this one I think bites more actually, bites the taxpayer more, is the capital gain disallowance. And that is, if you sell a non-capital asset between a partner and a related partnership or related partnerships, you just walked into ordinary income even though you thought you got 1231 gain. That one can hurt a lot more given the 20% rate differential. So you need to be very careful about the relationship of parties when you're doing sales there. You actually can get a similar result under Section 1239, which I think converts to ordinary income when the gain when you sell depreciable property to a related party. And actually, Roger had something like that rise yesterday, I think it was, where somebody wanted to sell a patent to a corporation, which I hope will make an S election, but that's another matter, trying to argue they could get capital gain. And I'm wondering if they don't fit in Section 1235 so that they can get pure capital gain treatment on the patent, do they just get all ordinary income under 1239 because the patent's clearly depreciable in the hands of the related party. Let's see, I guess I'm at my next slide, I think. Hit the down arrow. Ah, there we go, victory. Usually with the computer, when we have a problem, my wife and I call our kids, and I have my daughter here, so I'm in good shape if I get stuck. So partnership interest for services. This revenue procedure, which many of you are familiar with, 9327, provides, and I'll just read it because it's every word in there means something, other than as provided below, if a person gets a profits interest as opposed to a capital interest for providing services for the benefit of a partnership in a partnership capacity or in anticipation of becoming a partner, the IRS won't treat the receipt of the interest as a taxable event for the partner or the partnership. Because there is no 1032 for partnerships. They have somewhat of an equivalent, but not quite the same. The revenue procedure doesn't apply if the profits interest relates to a substantially certain and predictable stream of income from partnership assets, such as income from high-quality net securities or net lease and that type thing. Number two, and this one I've seen all kinds of commentary. I cannot figure out why this is here, but if within 2 years of receipt the partner disposes of the profits interest, and this can happen lots of different ways, involuntary, the partnership merges, all kinds of things would cause a disposition that wasn't planned by the recipient partner. And then it can't be a limited partnership interest in a publicly traded partnership. To further kind of confuse the issue, the IRS or the Treasury issued, I guess the IRS issued Revenue Procedure 2001-43. And this one in essence says, if you're in section 9327, and as long as you treat it consistently, we'll treat you as, we'll treat the service recipient as actually owning the interest. This revenue procedure is often relied on by many people to avoid the need to file a Section 83B election when you issue a profits interest. My recommendation is that you file the election. A basic rule of an 83 election, when there's time to do it, file it. If you didn't, none was actually needed. But if you have time, file it. Because if there's a sale within 2 years, you fall outside the revenue procedure. And number two, typically in the partnerships in which these interests are issued, you don't have a Section 409A valuation, although having looked at it in some of those appraisals recently in the case Lauren has, I got to tell you, you wouldn't want to be the expert on the stand trying to defend the thing. The bottom line is, if they argue it's a capital interest, you're outside the revenue procedure if they prevail. So if you're off a little bit on the value, boom, you're outside the revenue procedure. So either because of the 2-year rule, which again, I can't explain why it's there, or the fact that they could argue it's a capital interest, I'd file the Section 83B election. I think it's the safer way to go. Note also, the government's position, as I said before, is that this revenue procedure 9327 doesn't apply in the fee waiver circumstance where people are trading fees for increased profits interest in the VC or hedge fund. The IRS also issued, and sometimes I wonder what they're doing back there, they issued Notice 2005-43, which refers to a proposed revenue procedure and a proposed regulation that would, in essence, encapsulate what you have in 9327 and what you have in the other revenue procedure, the 2001-43, that basically would say, look, as long as you don't whipsaw us, you don't try to take a deduction at the partnership level, then we're not going to argue that the recipient has income, and we'll kind of leave you alone. All of this, I guess, derives from a case called the Campbell Case. I don't know if many of you are familiar with it, where the profits interest for services, and I think the taxpayer lost the lower level, and it went up on appeal, and then the Eighth Circuit kind of overturned it, and the taxpayer ended up coming out okay because the court realized that there really wasn't any there in terms of the profits interest. And one of the lawyers that tried the case, his name escapes me now, but he's been involved with McKee, Whitmire, and all those partnership guys for years. He told his client in the Campbell case that there was little or no chance that the IRS would argue that the profits interest had value. So every time this poor fellow would speak, his partners would always refer to him as little or no chance. So you just never know. I guess now I go to my next slide. Other items that came to mind. There's so many things to talk about with partnerships. I really found it difficult to try to cull things down to talk about today, but these are some other things I think that you should be aware of. And the first thing is, in section 1031, I know you guys must have this problem where you have, let's say, 3 partners, 2 want to trade and 1 doesn't want to, wants to cash out. It's a kind of recurring problem. I wouldn't suggest that you specially allocate the gain to the cash guy or lady, because the problem is you're not going to pay it out. You're not going to honor your capital accounts. And if you don't do that, then the allocation won't be respected, and then the government will turn around and reallocate the gain among the people who thought they were trading, thereby making them quite angry. This position was litigated by the state board, by the Franchise Tax Board, in a case called Appeal of Allers, 2005, where the Board of Equalization, you can tell they really don't understand capital accounts, but it was very clear when you get through it that the fact is they allocating the income to the cash out partner but not giving him the money. They said, no, it doesn't work. So they allocated the income among all the 3 partners or whatever was in the deal. Now, I never understand why the government cares, and somebody must have had losses. I don't know what, because somebody was going to pay tax on the income, so why do they care who does? I don't know, but either way, that was their litigating position, and they prevailed. So I wouldn't try specially allocating gain. When you have that problem, the only solution that I've heard of that works is to do this, which I've done at least twice, probably more. And that is to let's say you're selling $3 million of property, to keep it simple. You've got A, B, and C. So you trade for $2 million and you get an installment note for $1 million. Installment note, due the next year. You all know it's got to be due, in another taxable year. And then you distribute that installment note out to the cash out partner, and then he'll get paid in the next year. He'll get his cash. Because you distributed the installment note, there's no taxable income to the A and B who want to trade, and then I think you can do it. And I've done that in one of the cases I did. We had a lot of people, partners in the deal. It wasn't A, B, and C, but maybe you had 60 A and B and 10 in C. So we just distributed out a single note in which they had undivided interest, and it got paid the next year. And then we didn't have A and B pick up gain that they were never going to get in terms of the dollars. Another, I guess, issue that you should be aware of is the whole non-recourse, recourse debt area. And here, to me, the government just talks out of both sides of its mouth, but that's not surprising because we do too, depending upon which way we'd like the tax to work out. In a private ruling recently, the government ruled that Section 752 doesn't control for purposes of determining whether you have cancellation of indebtedness. In other words, whether debt's non-recourse or recourse for Section 108. Rather, it's their position. You got to look to 1001, which I have to say is not a model of clarity on the point, but that's their position. I wonder whether or not their position relates to the fact that there are also proposed regs under Section 752 that have a bias toward making liabilities non-recourse. And they adopted these mostly to deal with bottom line guarantees. I don't know how many of you dealt with UPREIT partnerships and whatnot, but very typically you'd have, one of my developer clients formed an UPREIT with a public REIT, and they contributed their heavily leveraged property into the partnership, and they had the classic problem, liability over basis. So what they did was they guaranteed the bottom part of the debt. And this was several years ago. The IRS doesn't like that, and the proposed regs are aimed at stopping the bottom line guarantees, and they try to do that by making everything non-recourse. So it's interesting, for purposes of cancellation of indebtedness, they want it to be recourse under 1001. For purposes of basis under 752, they want everything to be non-recourse, and maybe that's why they're taking the position that you look at 1001 for purposes of recourse and non-recourse. I assume if it ever gets litigated, though, it won't be so simple for them when they go to court on the issue, speaking out of both sides of their mouth. Another issue that you should be aware of is altering the sharing ratios in the partnership agreement. And here there are a couple things that are critical. Number one, the timing of the amendment. If you amend the partnership agreement to change the allocations, you need to make sure that amendment gets adopted before the return is due, not counting extensions. You can't count extensions. That's number one. And number two, even if you do amend the partnership agreement after year end, if you're trying to retroactively allocate a distributive share to a newly admitted partner, that won't work. The IRS has a revenue ruling on that. I think it's 77-310. I think the regs under 706 probably deal with the same thing. And where this will typically arise, you have some partnership and you've got losses through year end, you can't really pay them, you're leveraged, you've borrowed from the bank or something, and you bring in your money partner in December and you say, here, I have a great deal for you, come into the partnership, I'm going to give you all these losses that were incurred for 11 months before, and the IRS says no. You either close the books or do days in, days out, but you can't retroactively allocate the losses when you've got a capital contribution coming in. This doesn't affect the service partnerships, which typically probably wait till the return is due to figure out how they're going to split the profits for the year, because there's no additional capital that came in during the year. And again, you're not allocating losses, you're allocating income, so the government typically doesn't care so much. The last thing is the issue of partnership terminations. As many of you know, if you have a sale exchange of 50% or more of the total interest in partnership profits and capital, that can cause the termination, which creates some accounting problems for you and related tax problems. And one thing to keep in mind as a possible way to avoid that problem is that the redemption of a partner's interest, even though it's a sale or exchange for capital gain purposes, other than 751 hot assets, always an exception, that's not a sale or exchange that causes a termination. So if you redeem somebody, you liquidate their interest, that's not going to cause you a problem for termination under Section 708. And with that, I will stop. I don't know if you have any questions on partnerships in general or any of the things that I spoke about. Sure.
I have a couple, I guess. So, I'll just look at one first. So, you mentioned about the fee waiver,
Right.
being issued in venture capital.
Right.
And so, one law firm indicated one way to cure it is to, or like maybe minimize the risk, is to instead of having the management fee go directly to the management company,
Right.
to have it go first through the general partner, and the general partner pay it out. And I'm not the tax person.
Right.
Trying to understand these things. And somehow, I think it had to do perhaps with them creating a profits interest or somehow with the substance. Can you explain that a little?
Well, to me, it sounds like a substance over form issue because it's the shell game. It's just going to go around. I mean, I think one thing that the IRS auditors are pretty good at, to the extent they're not overwhelmed, is they're pretty good at following the money. And it just sounds to me like it's just going around in a circle. And when you look at these proposed regs, they're drafted fairly broadly. Now, admittedly, proposed regs, I think the authority is like a law review article or something. But somehow, depending upon how the courts feel, sometimes they rely on them anyway. So I wouldn't think that would work. I've never been a fan of the fee waiver, and I think the party doing that needs to understand they may not get the money. I mean, all the time these funds, I mean, very rarely do they hit it. So maybe 1 out of 10 or something does it. So when you give up your, was it the 2.5% management fee or whatnot that you otherwise had in the bag on the upside of getting some profits, until that deal closes that's going to give you the money, you have no guarantee you're going to get it. So my view is take the money, pay the tax. You're not in a 100% tax bracket. But I think the government's argument there would be substance over form. It's just a shell game.
I guess part of it is, looking for the funds, like you've got certain people who are the general partners.
Right.
They don't necessarily want to make the capital contributions, so
Right.
there's things you can't argue about. And just actually another quick question in terms of, you mentioned draws versus W-2 income.
Right.
And so it's really, because I'm in venture capital, so I get to see a lot of
Right.
interesting things. So I guess my question would be, that's from a federal standpoint.
Right.
But I guess my understanding is that it does create an issue on a state standpoint, though, if you do it as a W-2 versus a draw, if draw is more favorable.
Well, first of all, I don't think it works. I think the government is unfortunately correct that it's not proper to give the W-2. I think if you do that, you are going against the published revenue ruling. And so, Lauren will tell you when she talks, they love to penalize you. And they start off with, you owe more in penalties than you do in taxes. And so you've gone against the published revenue ruling that's been there for years, that Congress has been aware of. I don't know exactly how to answer your question because it's not a line I'd cross. I wouldn't do it. I don't see the benefit of it. And my worry is that somebody's not going to pay the tax. And because I think if the tax gets paid, I don't think the government has a complaint. But if you treat them as an employee, but then you rely on them, or your partnership agreement says they have to come up with the money, but they don't. I always assume they won't come up with the money. Why walk into that? You're right. The draw is better because it's not necessarily taxable income, depending upon whether there's income or not in the partnership. But it may be taxable income because they don't have basis. I don't know. At the end of the year.
So it's funny, these folks have egos, so they want me to say, like, pros or cons.
Mm-hmm.
So like, you say this is not best practice, then they're like, they kind of want more specific. So maybe I could talk to you offline a little bit.
Okay, I think, and this gets more in Lauren's area than mine, but I think as much as I dislike the government, and I've disliked them for 41 years, in terms of I remember when I was at NYU, one of my professors said to me, Mr. Rinsky, the taxpayer is not always right. And I said, when the government pays my fee, they can be right. So the bottom line is, my bet is that they would go after you for penalties, because I don't think there's any support for that position. You are a partner. If you're a partner, you're a partner. So, other questions? Well, one other thing that occurred to me on the fee waiver, and this isn't a tax. We have securities lawyers in the law firm who know more about it than I do. I'm dangerous in the securities laws, but I always have a lot of trouble when you're doing the fee waiver. How can you possibly make adequate disclosure if you're so sure the profits are going to be there to give you capital gain when you make the switch? Why the heck should your partners agree to let you do it? Right? Why isn't that a breach of duty to your partners? Why isn't that some kind of securities thing? I think it's a little facile when you do that, because you're only going to do it when you think the profits are in the bag. So I'm sorry, next question.
It's just on unreimbursed partnership expenses.
Right.
And how important is that to be in the agreement? And as just sort of like a preparer, I always kind of threw a bunch of stuff on there, maybe a few thousand out of pocket. Is that a best and normal practice to have UPE offsetting on the Schedule E on the partner's individual return, assuming they're an active partner? So if they're like paying a couple thousand extra for CPE, I say, oh, get it in your partnership agreement, make sure you have that. Is that a normal thing?
But it depends on the deal. But I would put it in for two reasons. I think number one, actually, wouldn't be the tax reason. Just to avoid disagreements in the partner, are you entitled to reimbursement, and what are the standards for reimbursement and whatnot? And second, I think it just makes the tax argument easier. But to me, a lot of the issues and whatnot that arise in the partnership area have to do with your agreement and whether you're following it and whether you've thought it through. So I would, from a business standpoint, do it just so partner C doesn't complain. I didn't agree you could be reimbursed. Who says I said you could do that? And because, as many of you know, the beauty of partnerships is the flexibility. The downside is when there's trouble, it's like a divorce. And people get real mean. Okay, any other questions? Okay.
All right, well, thanks very much, Art.
Okay.